Hello everyone, I'm Sidhant. I have started the lecture series of JAIIB, the legal and regulatory aspects of the banking, and these lectures consist of part A. Each chapter consists of part A and the part B. The part A has the lectures and the part B has the question and answer sessions, the important probable questions that could be asked in the JAIIB examination. So before starting, I would like to mention one quote, a very beautiful quote, that the things are difficult at the start, messy in the middle, and easy at the end. So whatever you do, you must keep the things going on and just take it at the last, because at the end only you will get to know what will be the result of your efforts. So I have prepared the objective questions, which are probable one, which could be asked or not, but it will give you a revision at least. So the first question is the objective of issue banking license. What is the objective behind issuing of the banking? So what is the need of the banking license? So there are two main purpose, which I have already mentioned, that continuance of the healthy bank. Only healthy bank will be allowed to run in the Indian scenario, and to restrict the indiscriminate formation of the banking companies. So as it's directly or indirectly related with the public interest, so it is very much required to give the license only to those who are healthy one, and only to those whose management is quite at par with the economic condition of the country. The second question, the RBI decision not to grant banking license can be questioned in a court of law under dash consideration. I will directly answer because it's a judicial term that is being used. The answer is extraneous consideration. Under the extraneous considerations, the RBI decisions of not granting the license can be challenged in the court. The question third, what is there in the section 11 of the Banking Regulation Act? The Banking Regulation Act, the section 11 is related with the paid up capital. The minimum requirement of opening banking companies or having shares of the banking companies is written in this section, and what all capitals are required, what kind of shares are allowed. Only the ordinary shares and the equity shares are allowed. Preferential shares are not allowed. Question number 4, section 22. What is section 22 of the Banking Regulation Act? As we have seen, the section 11 deals about the minimum paid up capital requirement, and what if RBI wants some extra requirement for some special bank to open a business in India. So the section 22 deals with that. It's a higher requirement that is required, expecting from the Reserve Bank of India, RBI expecting from the bank to open a business in India. The question number 5, appeal against cancellation of license. Within how many days the one bank can appeal against the cancellation of the license? Is 30 days. Within 30 days they have to appeal, and where they could appeal to the central government within 30 days. What is the additional requirement of the RRB's license? So this is a very this question, all these questions are asked somewhere. So additional requirement for the RRB's license is through NABARD. It gave an application to NABARD forwarded to the Reserve Bank of India. The question number 7, the foreign bank capital requirement. As we have already seen in the lectures, the chapter 2 of part A, that I have already mentioned this, but here I will again mention it so that it could be revision for you. The foreign capital requirement, the deposits that foreign banks has to keep is 15 lakh and 20 lakh respectively. 15 lakh in other than the states of Bengal or Maharashtra, or other than the Mumbai or Kolkata, and if the branch is in Mumbai or Kolkata, then they have to deposit 20 lakh rupees. And this 20 lakh could be a cash or unencumbered securities. You must have known that what is unencumbered securities. Unencumbered securities are those securities which are not taken, which are not put as a mortgage or some encumbered properties in any other place against the loan, etc. The condition of the Indian bank to open a branch, that they have to deposit, if it could be divided into two, that is if it's in only one state, or in it has its branch in more than one state, then they have to deposit 5 lakh of rupees and 10 lakh of rupees. 5 lakh if it's in the one state and more, and other than the Mumbai and the Kolkata, and if it's in Mumbai or Kolkata, then they have to keep deposit of rupees 10 lakh rupees. What if the bank is running only in one state? Then they have to deposit at least rupees 1 lakh. The minimum requirement is 1 lakh, and with every branch they open in the districts, in the same district the branch is already there, then they have to deposit extra 10,000 for every branch. And if the branch is open in other district of the same state, then they have to deposit plus 20,000 of with every branch they open in the particular state. And the same case, and the maximum amount, that is 5 lakh, should not exceed if they are running in only one place. And in the case of Mumbai Kolkata, the conditions are 5 lakh plus 25,000 with every branch, and overall 10 lakh rupees. This you should keep in mind. Question number 9, the paid up capital and the subscribed capital and authorized capital. I already had mentioned, I already had let you understand what all these terms are. If you do not know, then just see the previous lectures. And the conditions from this, the question could be asked, which sections describe that paid up, subscribed and authorized capital? Then it's under section 12, Banking Regulation Act. And what are the conditions? That the authorized capital must be double of subscribed capital, and subscribed capital must be double of paid up capital, or in other way around, that half of the paid up capital is half of the subscribed capital, and the subscribed capital is half of the authorized capital. The question number 10, the share transfer maximum 5% requires a RBI permission. Maximum brokerage is maximum 2.5% of every share transfers. Capital expenses written off, then dividends are announced. What consist of the capital expenses? Before announcing of any dividends of the shares, you have to first pay the capital expenses, then only you can announce the dividends. The capital expenses includes preliminary expenses, organization expenses, share selling expenses, loss incurred. Just keep in mind, depreciation is not included in that. This question could be asked, that what among these are not included in the capital expenses? Business prohibited under section 6.1. As we know that there are lots of businesses like selling of the articles or goods is not allowed to the banking, and it's mentioned in the section under 6.1. So even if some company, some banking company has their subsidiary, like Punjab National Bank has a PNB MetLife, they should also comply this under section 6 of 1. Then only it will be allowed to run in the So question number 14, the percentage of specialized directors required in as a board of director in banking company is 51%. The banks cannot deal. This 51% is a minimum criteria, maximum could be 100%. Banks cannot deal with all companies in which directors have substantial interest, 5 lakh or 10% paid up capital. In simple, if some of the board of the directors have their interest in some of the companies to which the bank is giving loans, then, and if the interest of that director to that company which is taking loan is 5 lakh or 10% of the paid up capital, or they have the shares of this amount, then this could not be done. this is the recent case of ICICI and Vodafone case, where Chanda Kocher's husband has some interest with the Videocon, and they have given a lot of amount of loans, around 800 crore to the Videocon. So this you can frame in your mind with the examples, you can understand. The tenure of the director, the maximum tenure of the director is 8 years. Just keep in mind, these questions are confusing, but this question could be asked. And MD CMD, the maximum is 5 years. You must have known understand the differences between the directors, board of directors, and the MD and the CMD. The directors are taking the decisions with respect to the company's with the company's goodwill, and CMD and the directors are the implementer of that policy. This is the difference. Chairman, whole time, and the MD exercise their powers under the control, supervisions, and directions of all these four things, like shareholders, board of directors, Reserve Bank of India, and the company law board. Among they have to follow the directions of all these, and they have to act according to them. And for being directors, the condition of the qualification of shares exist, and for being MD and chairman, no condition of the qualifications shares exist. You must know that what is qualification shares. In order to run a company, there are some sponsors, there are some people who are the members of the company who really profited if the company runs good. So they are the part of the board of the directors, and the MD and chairman are the appointed one who runs the company on behalf of the shareholders. That is MD and CMD. So the qualification shares is required, those who are the owner of the company, and those who are not, they don't have to buy the qualification shares. Appeal against removal within 30 days to central government. If some CMD got removed, then they, like Chanda Kocher got removed, she could have appealed to the central government, but as the central government and the RBI has put her off from the company, so she can't have any say, because she might be of guilty. It hasn't been proved, but she might be guilty, so she didn't appealed. Temporary appointment, maximum 4 months. If no CMD is there, no chairman is there, then there could be a temporary appointment of 4 months, not more than that. If office lying vacant, might be a resignation from the CMD or might be the death of the CMD, then RBI can appoint a new CMD for the maximum period of 3 years. And section 36 AA, this is very important section. Removal of anyone. RBI has the power to remove anyone if they are detrimental to the public interest, or they are not working in the interest of the people, deposit, etc. Then they can remove anyone. I would like to give you an homework. Please do it. It will benefit you very much. The question 1, under which conditions license required by the banks? Under which conditions license required by banks? Means for what purpose? For what purpose they have to take the license from the Reserve Bank of India? On what ground license can be cancelled? Just state 3-4 points on what grounds a license can be cancelled. The third question is creation of what takes place after the provisions of the section 26A of the Banking Law Amendment Act 2012. You have to answer these 3 questions. Nice day.